students, dear faculty members, dear colleagues of the Geneva Academy. Welcome to this opening ceremony, which marks the beginning of this new academic year, 2020-2021. I'm Gloria Gajoli, Professor of International Law at the University of Geneva and the new Director of the Geneva Academy of International Humanitarian Law and Human Rights. I replaced Professor Sassoli last August, who led the Academy for 2 years with a lot of expertise and dedication. I'm extremely happy to see so many faces present today at the campus biotech and to know that many more persons are attending online. What an achievement to be together. Together in a context of global health crisis that has in many ways led to restrictions of our freedoms and additional barriers. Thank you for being here. The Geneva Academy team has worked very hard. I can tell you, I saw that during the summer. They worked very hard to make sure that you, our dear students, were able to come to Geneva to attend one of our 3 master's programs and to make sure that all our courses can be offered in blended teaching. And it was really worth it. Listen at these impressive numbers. For our LLM in IHL, we have 48 wonderful students, 44 in person, 4 online. For the MTJ, we have 30 talented students, 25 in person, 5 online. For the Executive Master, we expect 44 participants, 18 in person, 26 online. This leads us to a total of 122 participants, and this in the middle of the COVID crisis. Participants come from Europe, but also Middle East, Africa, Oceania, North and South America, and Asia. There is also an incredible diversity of profiles from students, some of you with already substantial working experience with human rights NGOs, humanitarian organizations, the military sector, domestic and international courts and tribunals, diplomacy, the private sector, and academia, for instance. This diversity, we have it also among the faculty members with professors from our parent institutions, the University of Geneva and the Graduate Institute of International and Development Studies, but also from 15 universities around the world, including Glasgow, Pretoria, Essex, Cairo, Paris, to name a few. We have also practitioners from various organizations such as the ICRC, Geneva Call, the UNHCHR, Humanitarian Dialogue, or the International Center for Transitional Justice. I would like to seize this opportunity to say a big thank you. Thank you to professors who have adapted their courses to accommodate blended teaching and who are working extra hours together with the teaching assistants to ensure the best learning experience. I would like also to say welcome to professors who are new on the faculty of one of our master's programs. Welcome to Giulio Bartolini, Andrea Ziegler, Robin Geis, Salvatore Zappala for the LLM. On the MTJ, we have Katia Papagianni, Paola Gaeta, and Sarah Nuven, who are teaching now this year. For the XMAS, we have Lindsay Cameron. I hope you will enjoy sharing your expertise and experience with our students. I need 2 more thank you rounds. One, of course, for the wonderful team at the Geneva Academy, which is coordinating the master's programs, organizing rooms, ensuring that the technique works well, helping students with their visas and requests. Thank you, Danny, Tatiana, Lucy, Anna, and obviously the TAs, which are an essential asset in our master's programs. Last but not least, I would like to thank you, dear students, for your flexibility, your enthusiasm, your eagerness to learn with or without masks. I really do hope that you will enjoy this academic year, develop your expertise and network, and keep your dreams to make a better world and work towards that end, like our keynote speaker. I'm very honored now to introduce to you Ms. Catherine Marti Uel. She's head of the International Impartial and Independent Mechanism to assist in the investigation and prosecution of persons responsible for the most serious crimes under international law committed in the Syrian Arab Republic. You can just remember IIM. She has a wonderful career in international law. She started working as a judge, handling offenses by juveniles in France. Then she joined the MFA and focused more on human rights. During her time at the MFA, she got the opportunity to go to former Yugoslavia. And then from there, she continued to develop her career in international law. She worked at the ICTR, in the extraordinary chambers of the courts of Cambodia as part of the UN peacekeeping mission in Liberia, as the ombudsperson to ISIL and Al-Qaeda Sanctions Committee, and now for the IIM. So let's listen to Ms. Marchi-Uhel and learn how to navigate a career in international law. Catherine, you have the floor. Thank you.
Thank you, Professor, and thanks to all of you for coming to listen to me tonight, and those of you doing so remotely. I'd like to thank the Geneva Academy for this opportunity to give tonight's opening lecture for the 2020-21 students. You've chosen to enroll in one of the Academy's prestigious master's program, and this marks your commitment to getting equipped to address contemporary challenges in the field of international humanitarian law, human rights, transitional justice, criminal law, or the rule of law more broadly. This is a brave step. Career choices are always difficult and uncertain, regardless of your age. Working in this field requires a willingness to embrace the unknown, to be motivated by a cause, and to push ahead even when you may not always know in advance what you sign up for. Most importantly, remaining open, making use of opportunities when they present themselves, and not giving up on principles. The programs ahead of you truly resonate with me as a practitioner of human rights law, international criminal justice, and transitional justice. I'm not going to undertake a chronological dive into my professional path. Instead, I thought I would share with you some reflections arising from my experience in 3 areas, which I believe are particularly relevant to these contemporary challenges. Namely, and firstly, accountability mechanism for core international crimes. Secondly, the intersection of human rights and transitional justice. And thirdly, and finally, diplomatic and managerial aspect of an international law career. So let me start with the mechanism. I have the privilege of heading the first of a new generation of accountability mechanism, the International Impartial and Independent Mechanism. I'm not going to go for the long title. Also referred to as the Syria mechanism or the IIIM. The IIIM was born out of a political deadlock in the Security Council in relation to the Syrian situation. You remember that a referral to the International Criminal Court of the Syria situation was vetoed. Limited Security Council action on chemical weapons, ultimately also subject to the veto, didn't provide a platform for comprehensive and impartial justice. Without the Syrian state agreeing, the path toward justice for the victims and survivors seemed blocked. Multilateral action by the United Nations seemed impossible. And at the same time, Syrian civil society actors continued tirelessly to document atrocity crimes often at risk of their own safety. And individual states started to make use of universal or other forms of extraterritorial jurisdiction to prosecute core international crimes committed in Syria. In December 2016, after the situation in Aleppo worsened significantly, the General Assembly created the mechanism. A total of 105 states voted in favor of the resolution, sending a clear message that there could be no peace without justice in Syria. At the same time, the creation of the mechanism added value in practice, bringing all existing information and evidence together, filling gaps, applying criminal law standards. Our creation ensured that the necessary preparatory work to support present but also future justice opportunities, including at the international level, would commence now in order to permit holding accountable those responsible for the most serious international crimes committed in Syria since March 2011. The triple aim is neither a court nor a tribunal. It's not even a prosecutor's office, though we've been called a quasi-office of the prosecutor in the past. Some of our characteristics include that we bridge the gap between traditional human rights fact-finding and justice institutions. We act as a facilitator, as a justice facilitator for present and future justice opportunities. We apply criminal law methodologies and approaches in our collection, preservation, analysis of evidence, case building, and sharing activities. And we use state-of-the-art evidence management technologies and systems. When I applied for the position of head of the mechanism, I didn't know entirely what was awaiting me. I was motivated by the opportunity it presented. I saw it as a chance to build on the many lessons learned by national but also international courts and tribunals that prosecuted core international crimes since the 90s. I was fortunate to work for several years for some of these more traditional ICL entities. And when serving as an international judge in Kosovo, for instance, in 2001, side by side with other international and Kosovar judges, I experienced how difficult it was for us to efficiently handle the specific requirements of proving, for instance, war crimes or crime against humanity. The evidence collected in the course of the investigative phase of the cases we were handling was generally focusing on the individual conduct of the accused rather than trying to address the contextual chapeau requirement of these crimes. At the time, I remember I struggled to obtain support from the from an ICTY expert on armed conflict who was working for the Office of the Prosecutor and assigned to the Milosevic case. I finally got the green light from the ICTY for his participation as an expert in our case. I informed the parties, stopped looking for alternatives. However, only a few weeks before the start of our trial, I learned that the expert wouldn't be released by the ICTY. At the time, the Office of the Prosecutor was seized of challenges brought by the defense to its practice of calling as expert witnesses members of its own staff. With my colleagues, we rolled up our sleeves and started analyzing the amount of open source material available in the case. As you can imagine, that was not amounting to the expertise an ICTY expert would have brought to our case. During these years serving in Kosovo, I was at times overwhelmed with the work we had to do without the benefit of the resources and expertise the prosecutors of other tribunals had. This was also a very strange and humbling experience on the bench, particularly in cases where we sat in panels of international judges only. Firstly, because we international prosecutors or judges were operating in domestic international courts, and we had often less knowledge of the domestic substantive or procedural law applicable than the defense counsel. Secondly, because in such circumstances, some of us were tempted to rely on more familiar procedures from our domestic law, and this could prove very problematic. I remember a case where the prosecutor came from a system where proofing witnesses was acceptable. This practice was not accepted in the legal system applicable in Kosovo. We had called a trial at the request of the prosecutor in question a carabinieri who had been involved in securing the crime scene in our case several years before the start of the case when he was serving with KFOR. At the hearing, the witness didn't recall a specific aspect of the crime scene. The prosecutor got visibly annoyed and agitated and insisted, instead of allowing him to refresh his mind by reading his contemporaneous notes, which would have been permitted under Kosovo law, he reminded the witness of the proofing session he ran with him, saying, well, but Carabinieri, yesterday when I brought you to the crime scene, you had a perfect recollection of the facts. The defense logically objected to this, and we were not able to rely on the testimony of the witness ultimately. We also had to make sure that we would address this kind of issue in ongoing trainings for judges and prosecutors on the program. I later served as a senior legal officer of the ICTY and ICTR Common Appeals Chamber, and later as head of chambers at the ICTY. I was involved in the development of the court's jurisprudence on key aspects of its procedural law and substantive law, including challenges to indictments, elements of crimes and common purpose, liability, common responsibility in over 10 large ICTY cases and ICTR cases. I witnessed the amount of resources invested by the prosecutors in these courts in identifying crime patterns, organizational structures involved in the commission of crimes, as well as the role of individuals within these structures. This has shaped my vision for the AAAM. There are also two lessons I learned from the legacy of these courts that have shaped other important aspects of this vision. The first lesson directly arises from the reflection of prosecutors on the evolution of their approach in dealing with gender-based violence, including but not limited to sexual violence. The initial approach was to rely on standalone or heavily standalone teams in the area of sexual violence and other forms of gender crimes. This narrow and siloed approach led to the building of a few successful cases focusing on such crimes. For instance, in the Kunaraj and Al case, which led to the first conviction by the ICTY of rape as a crime against humanity, that's good illustration of the successful approach. I will revert to this case, which established how members of the Bosnian Serb armed forces used rape against predominantly Muslim women and girls as young as 12 years old as an instrument of terror. But this initial approach also had negative effects. In fact, the gender analysis was being likely to drop from the general investigative and analytical framework of these offices. Non-gender experts being of the view that it wasn't their part of their responsibility to integrate gender analysis into their core work. They were the experts for that. It really started changing when the ad hoc tribunals involved more members of the broader prosecution team and increased the number of staff acquiring gender skills. This permitted the development of more effective approaches. At the ICTY, it led to the establishment of a broad working group on gender in 2009, which managed to successfully integrate a gender approach in a number of cases. Give me 1 second. A powerful illustration of this new approach can be seen in the way the prosecution amended indictments and charged crimes committed in July 1995 in Srebrenica. As a result of this new approach, the ICTY Appeals Chamber was ultimately able to characterize the crime as genocide by looking at the combined impact of the killing of the men and boys and displacing the women, children, and elderly within the overall gender context of the Bosnian Muslim community. Had the chamber looked in isolation at the experience of the males and females and failed to consider the overall combined impact of on the specific community, arguably the crime of genocide would have been obscured. I'm convinced that these hard-won successes cannot be taken for granted, and that for the new generation of accountability mechanisms like the IIIM to successfully build on these, it takes a genuine commitment to implementing a proactive, multi-layered, and long-term strategy to integrate gender analysis at every level of their institutional environment and case-related work. The second most important lesson I learned from my time at the ICTY and ICTR Appeals Chamber is that victims and survivors of crimes deserve a dedicated and centered approach. I do not think that these ad hoc tribunals did enough in that area. They were conceived in an era where victims and survivors were primarily considered potential witnesses rather than subjects of rights. And in spite of the support brought to witnesses before, during, and after testimony, as well as outreach efforts towards the affected communities more broadly, a gap existed between these communities and the tribunal. Let me share with you an experience from an event I participated in 2004. It was an ICTY outreach and legacy event taking place in Foča, Bosnia-Herzegovina, southeastern part of Bosnia. Part of what we called the Bridging the Gap events. We were a team of investigators and lawyers, and we shared with the local community of Foča how the IIIM, how the ICTY had dealt with the investigation, prosecution, and adjudication of sexual and gender-based violence committed in their town as part of the ethnic cleansing that occurred during the war. One of the two cases we discussed was the Kunaratanal case that I mentioned earlier. The case illustrates how members of the Bosnian Serb Armed Forces set up and maintained a detention center for scores of Muslim women and girls who were transferred to other locations on a regular basis to be raped and gang raped. I have a strong recollection of some of the survivors being present in the room. They had found the strength to travel to Foča for the first time since the end of the war to attend the event. While it took place years after the crimes, in spite of the ICTY judgment, there was still a lot of denial in Foča about the reality of these crimes, as the questions from the local community showed. I was and am still impressed by the courage and dignity of the survivors. I remember my hope that accountability for these crimes and the broader transitional justice event would play a role, a small role, but important role, in recognizing their suffering, often stigmatized in their own communities, and would help to pave the way for reconciliation between communities in a country still divided years after the peace agreement was signed. That event is very much in my mind as we at the IIIM build our victims and survivors-centered approach. It's important to engage with victims and survivors and affected communities from the outset and try avoiding rather than attempting to fix the gap. I recall a specific occasion when recently, as part of a dedicated platform we developed at the IIIM, we engaged with victims and survivors of torture in detention and with victims of unlawful attacks and the siege imposed on their town in Syria. These encounters have been difficult experiences emotionally. It wasn't always easy to find the words and to show that I was not attending this engagement as a judge or as the head of the IIIM only, but as a human being, directly and genuinely moved by their accounts. No need to say that I wasn't always able to remain entirely composed. In spite of being heavy, these experiences allow me to remember at all times why I am doing this work. They are a source of immense motivation in my work. Finally, I witnessed the importance for national prosecutors as well as for international entities mandated for the search of the missing to be granted access to the information gathered by the international courts and tribunals, even years after the end of the trial. These experiences and those of members of my team at the AAAM are shaping our vision, as I said, of the implementation of this mandate. We are constituting a searchable central repository where evidence is preserved and can be retrieved to support all forms of accountability processes compatible with our mandate. We have a dedicated team responding to prosecuting authorities of states. We are building and populating a structural investigation of relevant analysis of the overall context within which the crimes were committed. We look at the crime patterns, the contextual elements for core international crimes, the structures underpinning the commission of crimes, the overall objectives, purpose, policy behind such commission, and the identification of the existence of one or more common criminal purposes. We look at factors relevant to providing the possibility of the commission of crimes for a range of potential modes of liability, including superior responsibility. And we also look, of course, at the impact of crimes upon the victim and the victim communities. We take a modular approach to case file development. This means that we are developing litigation briefs and underlying evidence that will form part of our own cases, but that can also be shared as such with jurisdiction to assist them in proving particularly challenging or complex aspects of international crimes, such as the existence of an armed conflict at a particular date for war crimes, the existence of a widespread or systematic attack against a civilian population, or of a policy to commit crimes for crimes against humanity, or the existence of a common criminal plan for co-perpetration or joint criminal enterprise liability types. We're committed to a two-way engagement with Syrian civil society actors. We don't consider them as mere providers of evidence, but as partners. Finally, our strategies to addressing sexual and gender-based violence and gender issues more broadly, as well as crime against children, as a core part of our work, and to support the search for the missing, and most importantly, our victim and survivor-centered approach are directly informed by these lessons from the past. Let me move to my second topic, the intersection between human rights law and transitional justice. During my law master studies at the University of Caen in France, my major was on judicial aspects. Human rights were covered, but at that time I had no indication that I would specialize in this field of law. I started my profession as a judge in 1989 in a district court in Normandy, and I specialized in emergency case for children, emergency care case for children, and cases involving juvenile offenders. I was also adjudicating civil and criminal cases involving adults at the court, including the court d'assises, competent for the most serious crimes. France had ratified the European Convention on Human Rights and Fundamental Freedoms in 1974, but cases invoking the convention were rare in that court. And I had already been a judge for 6 years when a first case involving the direct application of the ECHR was brought before me. The parents of a child under protection order invoked their right to access the entire file of their son, relying on a recent judgment of the Strasbourg court in a case against Belgium. Up to that point, I was summarizing the information provided by social services, medical services, members of the extended family and other witnesses in the case, but I didn't grant access to the entire file to the parents of the children concerned in the case. This European jurisprudence had not only the effect of modifying that aspect of my practice, it also had an important and direct impact on the way reports sent to my office were drafted by social workers and other services involved. can imagine that when you write knowing that the family of a child is going to have access to the report, you're not writing the same way. You're actually much more respectful, much more less judgmental, more as a matter of fact, in fact. I was fascinated at the time by the ACHR as a powerful protection tool and its direct application in French law. This triggered my participation in a training at the European Court of Human Rights, and a few years later, I joined a small team of judges and prosecutors seconded to the Ministry of Foreign Affairs to prepare the legal briefs and pleadings and represent France before the Strasbourg Court in cases where petitioners alleged violation of their human rights arising from judicial proceedings. I held that position for 3 years, and here I must make a little deviation to explain how I ended up at the intersection of human rights and transitional justice. Shortly after I started my career in the judiciary, the war started in the Balkans. And I still remember vividly the images of the shelling of Sarajevo, where civilians were targeted by snipers, gaunt bodies behind barbed wire at Umarska camp, and of course, unbearable images of the victims of genocide at Srebrenica, and similarly in Rwanda. The ICTY and ICTR had been created by the Security Council, the Dayton Agreement at World Peace in the Balkans, and I was at the juncture of either returning to a domestic court or making an extra step into the international law field. For a reason that I won't develop here for the sake of time, it was obvious to me that at this juncture it had to be in international criminal law. However, in spite of sending several applications to the ad hoc tribunal for relatively low-level positions, I didn't receive any acknowledgement of receipt, let alone an interview. This didn't discourage me, and soon an opportunity arose to join for 2 years the first judicial assessment program set up by the United Nations in the field. It started with the UN mission in Bosnia-Herzegovina, the ancestor of what is now known as the judicial part of the UN's rule of law program. And 2 weeks later, that was quick, I attended an accelerated induction session in Sarajevo, trying to absorb at once the history of the Balkans, including the recent wars, the landscape resulting from Dayton, the local legal and broader culture, the UN culture, the various actors involved in the mission, but also outside of it, including the Office of the High Representative, the OSCE, the ICTY, the NGO work present in Bosnia-Herzegovina, and the list goes on. I was overwhelmed, but at the same time inspired. In these 2 years, mostly in northeastern Bosnia-Herzegovina, I got exposed to the multifaceted aspects of transitional justice in a post-war state, with inter-entity boundaries, the difficult task of restoring rule of law on the ground, of vetting members of the judiciary, monitoring sensitive court cases, and making concrete recommendations for law reform. The law reform sanctioned by the Office of the High Representative in the criminal law field, resulting in replacing the mostly inquisitorial system by an adversarial system. And this was complicated by the fact that judges and prosecutors had no experience of the main features of that new system, and that defense counsel, an important part of an adversarial system, were not equipped for. My role in the JSAP, the Judicial System Assessment Program, was to help members of the local judiciary to learn how to exercise their independence and impartiality in a context where the demands of the international community often replace the previous dictate of domestic politics. I remember a Bosnian judge pressed by an international colleague from the Office of the High Representative to make a particular decision. There were very good reasons for the judge resisting the pressure, but at the same time, there was a vetting process for members of the judiciary, and doing so raised fears that this may increase the risk of losing her position. In helping the judge navigating this difficult episode, I was able to rely not only on the jurisprudence of the Strasbourg Court or that of the Bosnia-Herzegovina Human Rights Chamber, but also on my domestic practice of applying the convention in my own country at a time when our Cour de Cassation was rather conservative. Fellow international judges in Kosovo and myself later faced similar situations. Once I received a call from a senior member of UNMEC seeking to influence my decision as to whether to impose a pretrial detention or not on a member of the Kosovo Liberation Army suspect of trafficking in weapons. A colleague of mine saw another UNMIC official taking the mission's helicopter to arrive on time to lecture him, literally, and try to influence the outcome of a sensitive investigation. On these occasions, it was important for us not only to take the right judicial steps, but also to mark our disapproval of attitudes incompatible with the very rule of law that we had been brought in the Balkans to help restoring. During my time as a judge in the pretrial chamber of the extraordinary chambers in the courts of Cambodia, it seems that I always get to a title that I'm possible to will notice. I had the opportunity to help building the capacity of my Cambodian fellow judges to apply the equality of arms component of the right to a fair trial. We worked together on a case involving at the time 4 senior members of the Khmer Rouge. In one of the numerous appeals in that case, we were seized by the defense of a challenge to a decision from the co-investigative judges. The judges had applied to the letter a provision of the Cambodian Code of Criminal Procedure. However, it resulted in violating the right of the accused to know the case before them and to prepare their defense. Our unanimous ruling in that appeal quashed the decision of the co-investigative judges and granted the remedy sought by the defense. It was the first decision of its kind by a Cambodian court. The irony of the situation is that the Cambodian law was using the same language as an older version of the French law, which had to be amended in France for its incompatibility with Article 6 of the European Convention on Human Rights. This is ironic, but I'll just make a small aside here to tell you that we were told by NGOs working for human rights promotion in Cambodia that having a first decision by a Cambodian court with a majority of Cambodian judges on the bench was extremely important for their cause. This was not the end of my adventures at the intersection of human rights and transitional justice or rule of law. In 2014-15, I served as director of the rule of law pillar in the UN mission in Liberia during the major Ebola crisis. The epidemic gave us an opportunity to work with Liberian prosecutors in putting an end to unreasonable periods of pretrial detention, which probably saved the lives of over 200 persons in overcrowded Monrovia Central Prison and other prisons in the country. Let me end with my third topic, namely diplomatic and managerial aspect of an international law career. Probably owe you a word of explanation of why would I speak of that to students at the Geneva Academy. For me, there are important aspects of an international law career, and they shouldn't be neglected. If you have the opportunity to develop your skills in this area, I strongly recommend you do so. I had some exposure, as you've heard, to the diplomatic field during my time as redactor in the Human Rights Law section of the legal division at the French MFA. In addition to ECHR cases, the job involved negotiating various international instruments under the auspices of the European Union, the Council of Europe, and the UN, in the areas of sexual violence, trafficking against children, involvement of children in armed conflict, as well as bioethics. But I clearly had to up my game when, in 2015, the Secretary General of the United Nations appointed me as the ombudsperson to the ISIL and Al-Qaeda Sanctions Committee. I was seized by persons or entities placed on the sanctions list by the Security Council Sanctions Committee who made a request to be taken off the list, meaning being delisted. My mandate was to gather information and to meet with the petitioner in person, if possible, to interact with the relevant states and organizations with regards to the request, and to recommend retention or delisting based on a thorough assessment of the case. It's an important responsibility in a field where the rights of listed persons and entities often clash with national security considerations. When the ombudspersons recommend delisting, his or her recommendation is implemented unless the 15 members of the Sanctions Committee, which are representing the same state as in the Security Council, unanimously disagree with that recommendation. And it has never happened to this day. You can imagine the amount of pressure that states could exercise in that area. It provided me with an opportunity to test the requirement of being independent and impartial in a much more challenging environment than in the domestic judicial system. In a way, it was an excellent preparation for my current job. I'm closing the circle by ending where I started, here in Geneva at the AAAN, to stress the importance of managerial skills in an international law career. My judicial functions did not necessarily prepare me for it. Fortunately, when serving as head of the chambers at the ICTY, I had the opportunity to develop these skills, and I was leading a section of the court servicing the judges. At its peak, our section counted over 100 staff, and including lawyers and administrative staff. However, heading an independent institution situated in the UN Secretariat, like the AAAN, implies more responsibilities, including in human resources, management of assets, budget, and finance. I am responsible for the integrity of the entity's operation, as well as the safety and health of our staff, including when we go to the region. I would like at this point to raise your awareness about an often overlooked issue, secondary trauma or vicarious trauma. It refers to the indirect trauma that can occur when we are exposed to difficult or disturbing images and stories secondhand. It relates to the many ways in which work with traumatized individuals or exposure to traumatic materials can psychologically, physically, and spiritually impact professionals in the humanitarian field, but also in the international criminal law profession. This is an issue too often considered taboo among investigators, analysts, lawyers, prosecutors, and judges. It takes a dedicated approach and a strategy to address it in an effective way while respecting confidentiality and sensitivity surrounding. Both in my domestic and international path, I've been repeatedly exposed to distressing experiences, and I have learned how to recognize the signs of secondary trauma in colleagues and also in myself. I have at times sought professional help myself. The situation in Syria is inherently traumatic, and it's important to understand the potential impact this may have on those who work on it. In my current position, I'm committed to adopting and implementing a dedicated strategy to make sure that we receive training, that we have tools and support at our disposal whenever needed. This is particularly important if we want to deliver results and make sure that we support justice efforts for Syrian victims and survivors of the horrific crime they suffered. To conclude, I hope I managed to whet your appetite by touching on a very broad range of possible topics you may encounter as part of your future career in international law. It can involve many different aspects and facets. So stay abreast, stay on your toes, be creative, embrace the unknown, and most importantly, never stop learning. I wish you a successful and inspiring academic year. Geneva offers the opportunity to make use of them. Thank you. I understand we have a possibility of Q&A. Are we taking one, several, and I respond, or one after the other? A few? Okay, so I'm taking notes, just make sure. Yeah.
I would like to say thank you for being here and for telling us your stories. It has truly been a pleasure, at least for me. I have two questions. The first one is, what has been the biggest challenge you faced as the first head of the Triple IM, with it being a new entity, in addition to the secondary trauma, of course? And the second question is, what has been the biggest challenge to the Triple IM in ensuring respect for international humanitarian law, human rights, and other international? Thank you very much.
Mm-hmm.
My question is a bit similar, but as a woman, did you have any specific challenge during your career, especially when you go in other countries where maybe there's less women in managerial cycle like you had? So did you have any specific
Mm-hmm.
My question is on how it was for you during your time as a judge in France to deal with international law rules in the domestic jurisdiction. I come from Brazil, and there are I could see a lot of ways that it's not very possible to apply international law domestically, especially from the judge's part. So I would like to see how you see that this is possible within the domestic jurisdiction. Thank you very much.
Mm-hmm.
My question relates to, it's more kind of a practical question. Does the Triple IM, for example, cooperate with the Commission of Inquiry, which was established by the Human Rights Council, which also has an evidence gathering, fact-finding mandate?
Mm-hmm. Okay. Shall we answer these first and take a second round? No? Okay. All right. That's been my first challenge as a head of Triple IM. Constituting a team, I think probably. I was lucky that Prince Said, the then head of the OCHR, had constituted a skeleton team, a small team to support us, and also had secured premises for us in the Palais. So that was not a small thing, I can tell you. You're right. Probably the main challenge at the beginning was that I didn't get one day between the two jobs, right? And I probably for an entire month, I think I learned, I was appointed, yeah, literally a month before taking up my new functions. And I had to prepare a plan for the succession. I knew that the ombudsperson for ISIL and Al-Qaeda, based on the experience of my own appointment, had taken almost over 6 months, sorry. So I knew that for a while the office would be without a head, and I had to take particular measures. So that was taking a large amount of my time. I was based in New York, doing probably something like 3 a.m. to 3 a.m. to 9 a.m. My work with the time difference in Geneva, so that I could give direction to the colleagues from the small startup team and allow them to move forward with preparation. Then I was having my day as the ombudsperson dealing with cases, and then I had my evening or night preparing the plan. So that first month was probably the biggest challenge I faced. But more seriously, yes, constituting a team, a solid team that represents all the various field of work that you need in a mechanism like that, at the time where you're developing intense efforts to engage with very many stakeholders. I mentioned the Syrian civil society actors, but the states as well. You need to share this vision that you are in the process of developing and make sure that they understand and buy in this vision. So all of that was really the first big challenge at the beginning. Now, you also asked me what was the first challenge. That was for me, huh? But the challenge for the IIIM certainly was, and continues to be, how do you deal with a situation of that scale when you have no access to the country, when you need to find creative ways of convincing the stakeholders that have been involved in collecting information and evidence that they can not only safely, but also in a relationship of trust, share with an institution that is not a court, so that's a big disadvantage, the material in question. Well, you need really, that was a challenge that took months, and probably is not over, because it's something we put always back on the work. But that's something I think we have, it's clearly not credit going to me only, it's the entire team, the skeleton of maybe 20 staff members who were there during the first year, who have taken this part of the work really seriously and make sure that we could move forward. As a woman, specific challenges, you asked me about that in the context of going in the region, right? You're going to be probably surprised, but I think the main challenges I faced in that area of being a woman were not necessarily when being in the field in the Balkans or in the Middle East, probably because the type of positions I had there were such that it was a function, not so much a person that people were looking at. You know, a petitioner wants to be delisted, has no interest in starting to antagonize the ombudsperson because she's a woman. But more seriously, if you work with fellow judges on the bench in the region, or you make an assessment of the functioning of the judiciary, at the end of the day, if you're competent, people are going to recognize that. If you make mistake, whether you're a man or a woman, they will take it. You will still have to face the consequences. The place where it was more challenging being a woman, I would say, is probably the ICTY, because it was a very male-dominated high-level function. So getting accepted as a judge in the ICTY, as a judge, sorry, lapsus, as the head of chambers, one of the judges, I won't say which nationality because he could reveal who that was, told me, okay, Catherine is going to be fine. He'll be fine. As long as they don't realize they have a head of chambers, talking about his fellow judges. And that was kind of true, because I mean, head of chambers doesn't mean that you are a judge. Head of chambers means that you're leading the support team that helps the judges. So you have to be really humble. You have to accept that you propose things that may not fly. You have to do a lot of soul work, and at the same time, realize that you're not in a judge position. So in a way, having been a judge in my system and in Kosovo helped at that time, because I think I could play around with this changing hat and role. When I was at the ICTY, I was not a judge, and I never forgot about it. But the fact of being a woman clearly didn't help at the beginning. How did I manage as a judge in France to deal with international law? I have to be totally transparent here. The experience I had of applying international law in France was really in the context of the European Convention on Human Rights. Our system is recognizing the direct application of the convention in French law and as a superior level of law compared to French law. So that was my experience. Now, because you're also, if I understood correctly your question, you're also interested in how to apply international criminal law or IHL. Well, I don't have a personal experience of that, direct personal experience of doing it in France, because I wasn't dealing with international crimes, but I have a very clear understanding of how nowadays prosecutors and judges do it in national systems, particularly in Europe, but not only, and we deal with a number of them at the IIIM, because we're supporting their effort and we respond to their request for assistance. So they have two entry points for that. Either, well, apart from the classic entry point, which is, you've incorporated the Rome Statute into your framework. You have an accused that is a national of your state, or you have a victim that is a national of your state. Okay, classic. But we also have nowadays, as I mentioned briefly in my lecture, we have situations where prosecutors either apply a form of universal jurisdiction for such crimes, or more frequently, they apply an extended form of extraterritorial jurisdiction. So it would be, just to give you an example, enough for a prosecutor that the suspect is residing on the territory on a regular basis, or it would be, I'm not entering into detail. So in such a situation, they apply, either the domestic law incorporating and integrating the international crimes into domestic law, or laws adopting the frameworks of the crime foreseen in the Rome Statute. That's another way of doing it. But sometimes it's domestic laws that entirely domestic laws that are basically foreseeing the crime in question even before the creation of the ICC. You have a variety of situations, and for us, it's kind of a part of the challenge of, if you want to effectively support these many jurisdictions. At the moment, we are supporting jurisdiction from 11 states at the IIIM. Well, you really have to get accustomed to the legal framework so that you can adjust your support to their needs. How do we at the IIIM cooperate with the Commission of Inquiry? Well, we had a very clear request for that in our terms of reference, and even the resolution creating the mechanism was foreseeing that there would be cooperation. So we still had to implement that that expectation into taking concrete steps. So we negotiated a memorandum of understanding with the Commission to understand the basis on which they could share the material they gathered with us. As you know, the Commission of Inquiry, or as you may not know actually, the Commission of Inquiry is mandated by the Human Rights Council to report publicly on its findings in relation to serious violation of human rights law and international crimes. But of course, it doesn't apply the same methodology as described. They are not dealing with the same standard. We apply the standard that would apply before court, or at least at the prosecutor level, while the Commission of Inquiry applies a lower standard, but yet, even we're not only interested in the material they gather, the evidence, which when they have permission from the sources, they can share with us. We also have interest in the findings that they make, because it's really interesting to take that into account when we're looking at crime patterns. So we do look at, without incorporating those conclusions into our own analytical work, we do look at it to inform our work. And I think I've covered this first round of questions.
Okay, so we just have the 3 questions from online participants. So the first one, could you please explain a little bit more about how to deal with the challenge of diplomacy and the different powerful political interests to maintain the independence of a body like the IIIM? Then we have, based on your experience in Kosovo, I would like to hear your opinion on EU Lex, whether it was a good move in achieving justice, as in the country it's seen as a failed mission. And last one, at the IIIM, which are the main challenges relating to digital evidence For instance, how do you deal with authenticity issues when the provenance of video is unknown?
So, dealing with the challenge of diplomacy in an international career, I've given the example of my work as the ombudsperson because I think it's really a telling one, but as you've heard as well, I think you can be confronted to attempts of pressure, I would say, from, when you're in a mission and you have a mission statement and you have goals, etc. I mean, these judges are annoying, right? They want to do what they want. They have maybe a different vision than you have of what would be good for the mission. So temptation is serious to actually try to tell the judges what you expect for the good of the mission. And I think what's really important when you have a mandate that requires impartiality and independence is that, okay, you may have to listen to that. Well, first of all, if you think that the pressure is inappropriate, and certainly if you're a judge, it's totally inappropriate, you need to make it clear. But at the same time, you need to think a bit broader picture than that. What kind of message are we sending to the local judges and prosecutors? So we here often giving the impression we're giving lessons, which is not necessarily the best way of getting them to think about the issues. And on the top of it, the officials don't always respect the rule of law principles. It's really highly problematic. So I think finding ways to be respectful, you don't shout at people when they tell you that, but just trying to explain where are the limits and be firm on that. And yeah, it's easier for an international judge certainly than a judge, a domestic judge who knows that there will be an interesting vetting process ahead of you. And, are you going to be considered a difficult person, a difficult judge that doesn't abide with the mission statement? Well, so it's what I wanted to say. If you want to read a bit more about how the challenge of doing that as an ombudsperson, I invite you to read the last report I issued for the Security Council, which was, hold on a second. Okay. So it was 2017 report issued it's every 6 months, so reporting issued in July, where I had the habit in my report to the Security Council of having a section talking about figures, how many cases did we deal with, etc., and having a thematic section. And I usually use that forum to kind of share with the council some concerns of mine or some areas where I think things could work better. And during the last year of my term as ombudsperson, I faced quite a few situations which were, in my view, highly inappropriate in terms of state trying to interfere with the process. States have the right to say what they want. They have to, but they also need to abide by the spirit of the resolution. So when they don't, again, it's important to kind of explain what it means. I'll just give you a very simple example. Some states had difficulty understanding that when one of the resolutions applicable to Daesh and Al-Qaeda sanctions committee, which required the ombudsperson to, I can't remember the exact word, I think to take into account the position expressed by the judges, by the states. And the word I come from, taking into account, means you listen, you consider carefully, and you decide what is appropriate to decide, right? But no, they understood, some of the states really understood that it meant you had to do what the states want, which was ridiculous in a way. I'm saying that with due respect, because states didn't always agree on what was the right thing to do. So how could I kind of take their views into account faithfully with no interpretation of what was appropriate to do in the case? So you see, I mean, I took a bit of an effort in that last report to just explain what it means being independent, being impartial in the context of that particular mandate, which again, states are very legitimate in expressing their concern about the national security interest being infringed and maybe placing people at risk. And when you take a decision as ombudsperson to delist someone, you'd better get it right, because if you get it wrong and the next day the person is involved in a terrorist act, I can tell you that you would feel extremely bad, right? So of course you take it seriously. It doesn't mean that you have to be a yes man and a woman. I'm not going to comment on the on the ULEX experience. It would be totally unfair on my part. I've never worked for ULEX, so, and I left at the time where I left Kosovo at a time where ULEX was about to take over the judicial component of UNMIC. So, well, you will have heard probably from my intervention that, you know, I'm myself putting in question certain things I did as a judge, and I'm always questioning, you know, could have we done that better? So certainly mistakes exist, and we learn from our mistakes. We try to avoid them in the future. But I'm not going to comment on ULEX specifically. How to identify, well, the question of credibility, authenticity of the material we collect, I would say, is no deep. I mean, there are differences with digital material, including videos, but the principles that are at stake are the same. You look, when it comes to evidence, you look at the credibility, authenticity of the material. You try, if possible, to corroborate. But of course, when it comes to video material, there are specific challenges which the technology, thankfully, should be able to help with. So we are using those technologies, but we're also trying to engage with partners who have probably even more knowledge than my team, which includes specialists in evidence management, the e-discovery field, if you've heard that in your studies. They don't have all the answers, so it's really a work in partnership with others confronted with the same problems and identify ways to use the technology to authentify some of the videos in question. We also have an important role in identifying duplicates, because of course you may have videos which are not exactly the same, can be a shorter version, can be taken a longer version, taken from a different angle, which in evidentiary effort can mean a very different outcome, right? So it's really identify those duplicates, those near duplicates, and being able to identify what weight should be given to the material in question.
So, Catherine, thank you so much for sharing your journey with us. I have two questions. The first one, in particular in relation to trial efficacy, do you see your national practice as an essential part to build foundation before bringing it to an international level? The second question is, throughout your legal career, where you either draft or hear testimony from witnesses who have gone through some jarring experiences, how do you build a mechanism where you can strike a balance between compassion and guarding against some of the emotions so that you can keep going?
Mm-hmm. And your first question was trial advocacy? Mm-hmm. As a party, as a counsel for prosecution. Mm-hmm. Do you have? We take a few more, yeah. Well, I keep thinking about it.
My question is also a bit like related to culture, because you obviously work with people from a lot of different cultures, and there's a lot of like things which are culturally appropriate or not. How do you deal with it? How do you deal with it? That it's like often like reflecting on legal opinions as well, like what is culturally accepted.
Culturally, you said?
Yeah, like I think often the legal opinion a person has is like influenced by their cultural acceptance as well. So I would like to know how you deal with that as you work with a lot of like cultures.
Mm-hmm. Interesting. Hmm?
What's the future after the triple IM?
Retirement. For real. Okay, I answered one. Shall we try to give it a try to one more? Yeah.
I wanted to commit an international crime by touching the mic. Sorry. And no, thank you so much for your presentation. Perhaps I wanted to continue with the question you asked. Do you think that would be quite useful for some of our students, that it was very useful for you first to work in a domestic legal system, or could you, especially today where international criminal justice and transitional justice has much developed, could you say today someone can as well directly enter into the international level? And then a personal curiosity, one of my greatest admiration for your institution is how you keep the confidentiality. I previously worked for the ICSE, and I have many former students who work for the ICSE and tell me too many things. And on Facebook and in emails and so on. While I must say, my impression is nothing comes out from you, including by my former students.
I beat them.
No? How do you manage that? Because today, with all these social networks and friendships, and people are, in my view, much more, they tell their friends what they do, which is, in my view, a real problem for the ICSE. How do you avoid that?
Okay, that's fine. So trial advocacy, well, as you've heard, I essentially worked from the bench, right, or in the chambers. So, I mean, obviously, and that's true in domestic courts as well as in international courts, having competent counsel from both sides is really an essential component of the right to a fair trial, I would say. But it's also an essential component of for the judge to be able to do either or work at its best, I would say. If you have a poor case, badly prepared, badly presented, and if you have a powerful prosecution and a defense which doesn't have the same means, will be always disproportionate because prosecutors have no means, but at least, you know, having a good understanding of the law, etc., this balance is really uncomfortable for a judge. And then you feel it's maybe your role. In the French system, we would say it's a bit easier for people from the civil law system because the judge is kind of naturally supposed to lead the trial and can ask questions if the defense doesn't ask certain questions, you can ask them. But in some system, it's really not even appropriate for the judge to do that. So I'm not sure I'm covering the aspect of your question that you wanted me to cover, but that's what I would say at this stage. Really important to have competent counsel from both sides, committed, competent, and of course with very different legal obligations. Some are common and some are very different. How to deal with, to balance compassion, professionalism. Well, I'm not sure I know how to do that very well. I mean, it's clear that it's a struggle at times because if you need to protect yourself if you do this work for years as I've been doing. But you know, if you protect yourself too much, you're like a machine. You don't appear as someone who is capable of understanding. Maybe I'll give you an example from my domestic practice, in fact, because I've given many examples of international law. As a judge in charge of juveniles, I often had, and more importantly in the children care cases, you know, parents who are extremely angry. They don't understand that one wants to come in and tell them that the attitude is maybe not the one that is acceptable, etc. It can become tense very quickly, basically. And you could say, okay, I'm the judge, so I'm deciding, and you shut up, or more politely than that. Well, you can't do that because you need to engage with the parents, you need to engage with the child. Same as when you have juveniles in a court for offenses. They're going to play with you and quickly try to put you in a situation where you're going to be at fault, or they will force you to tell them to quit the courtroom. Okay, that's fine, you can do that, you have the power, but what do you do then? So it's really learning always how to balance between your role, your humanity, engaging, maybe sometimes taking the extra step, which is to explain in person things that you could send in a written order, but you do it to try to, well, first of all, show that you are respecting the person in front of you. I would say, I know I'm not answering your question about compassion, but I think the same logic that applies. You have a human being there. And of course, you can start crying with the witness, the victim, or on the difficult childhood of the accused. But you need to be able to show your humanity in that. This profession is it's complex. Why do you become judges? In fact, some people would never want to become judges. Judging your fellow citizens. That's very. So if you do that, I think you have a special responsibility that comes with it, and that's probably difficult to answer your question. But I think you do your best, I suppose, and you accept that in order to be able to do that, in addition to the what I was raising at the end of my presentation, secondary trauma, you also need to find the right balance in your own life, I would say. Be able to kind of I never make this word in English, compartmentalize your life in the work, and have some sass in between, so that you can, when you are in your professional life, really 100%, and you can use your time with your family, with your friends to recharge the battery. That's very important. The legal opinions and the culture, it's complicated to entirely depart from your legal culture, because I guess that's what brings you where you are, and it's there. But you need to be conscious, especially when you work for internationalized courts or international courts, that you're not there as a judge of your system. You're there to apply a different set of law, and you can maybe feed your thinking by using examples from your domestic system. And often with your colleagues on the bench, you will have this kind of debate, common law, civil law, but not just. So again, that's complicated, your last question, that one. I don't know how to answer that. I think that your culture is present. It's probably as well to be self-conscious of your biases. So they may be cultural, they may be based on other grounds, but they may be cultural. If they are cultural and these are biases, well, be aware of it so that at least you're not falling into the trap, but you can rectify or balance the weight to attribute to that in your decision making. I answered the question on future, and that's not a joke. I think I'm 57, so I think after IIIM, I own my retirement, and I'll be reading your papers and all what the Academy is doing from my house in Normandy. Is it useful to work for a domestic system? I believe it is useful. It is not mandatory, but having the capacity, and I'm not here saying working as a judge, but there are many systems where you had to work as a judge before, that's the end of your career, so you probably couldn't. Fortunately, I come from a system where we entered the judiciary relatively early, but having practiced as a counsel or as a, having a practitioner's experience prior to joining an international setting, that's useful. Can you do it without? Yes, you can. I have interns that joined the ICTY when, and it was not their first experience, but really one of their first experiences, and they've done a career in international criminal law then from many other courts, and they're very good. So yes, you can do it, but it helps. And of course, I would say in my case, probably, it was not a joke, the story I told you about applying and not receiving a response. So by the way, don't give up when you face that, because it's not the end of the world. It's never pleasant, but if you have, later in my career, when having been a judge was clearly helping, because when you have accumulated the type of profile and experience that these courts or mechanism now want, and you can show that you have this little added value, potentially, well, that can help. How to keep the confidentiality high on the agenda of everyone in the team, that's a cultural thing, another culture. And that's about being serious about it, getting colleagues to understand that it's not just something you sign off on the day you arrive at the mechanism and that you can forget about. There are consequences for not respecting the confidentiality. And it's a number of layers. It's a need-to-know basis. Don't share what some colleagues don't have to know, because they're not going to be having to use that information in their work. They don't need to know. And I'm saying that coming from a culture where transparency, whenever possible, is really my favorite course of action. But when it comes to evidence, for instance, or specific strategic decision being made that don't have to be revealed at this stage publicly, well, you really have to exercise those layers of compartmentalization. So we do that, having confidentiality framework that is well known. People know what they have to do, the systems in place to make it respected, and repeating and repeating again. So it's like the mantra at the top end. But if you explain to colleagues why is that, is it because we just want to be secretive? And no, there is a reason for it. Either it's to avoid endangering someone or affecting the reputation of the mechanism, or say you have a cooperation with certain entities for which it's highly problematic to reveal that they cooperate with your entity. Well, you have to respect that. If you don't respect it, you may affect their ability to undertake their own mandate. So it's in no one's interest, and you have a responsibility to do it. Thank you for your question.